Process, winner of 18 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2010 Mid-Atlantic Emmy for Best Discussion Series.
What makes this year different than every other year in U.S. history is the fact that for the first time in 2 centuries, we now have 3 women sitting on the United States Supreme Court.
And this Supreme Court specialist, a lawyer who may hold the record for cases heard by the High Court, says the gender shift alters the tenor of the court, just as Thurgood Marshall once changed its complexion. Steve Shapiro, National Legal Director of the ACLU, here to help us follow what's been heard, what's been decided, and what decisions are yet to come. Our annual Supreme Court update up next on Due Process.
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.
They may be the 9 most powerful people in America. Their terms have no limit. Their decisions trump almost everyone, the president, the Congress, all the lower courts. They are the members of the United States Supreme Court. I'm Raymond Brown.
And I'm Sandra King, and spring is a time we look forward to each year, not just because of the break in the weather, but because it is Supreme Court prime time. The last few cases they'll hear this term, the bulk of the rulings they'll be handing down before their summer break.
So it's become an annual tradition here at Due Process to update the High Court year, to try to make sense of the cases, the characters, the losses, the wins.
And who better to help us through than the longtime legal director of the National ACLU, whose 90 staff attorneys and countless cooperating lawyers are involved this year in 1/4 of the cases the court will decide. Steve Shapiro, great to have you back on Due Process.
Well, thank you, Sandy. It's a pleasure to be here.
And just because you're a brilliant lawyer, you're the only guest who warrants a footnote. And that is that we like to have Steve on as a guest, despite the fact that he's an advocate, because he's also a professor, and we find him very skilled at explaining both sides of the issues with fairness.
Well, thank you.
Let me start with something that probably shocked a lot of Americans, because the behavior of a certain group was pretty reprehensible in the eyes of most Americans, I think, at funerals. And the question before the Supreme Court was, does this implicate the First Amendment and free speech? What happened with that case?
The Supreme Court said the speech did, and that the protesters from the Westboro Baptist Church
who were protesting not anything to do with those soldiers, but
they have now made a habit of traveling around the country and appearing at the funerals of deceased service members and carrying signs saying, in essence, that the death of the particular service member is God's retribution on America for Americans' tolerance of homosexuality.
But Sandy's right in the sense that literally they had been saying this before this land's corporal died. On the other hand, you can't deny that the family in a situation like that, although this family became aware of much of the detail of what they said after the fact, is pretty distressed when a funeral is affected. How did the court address the issue that there really was an infliction of distress on this family, and that was the narrow issue in which they started the suit?
Well, I think there are several things to be said about the case. One is it was extraordinarily hard on the facts. I don't think anybody questioned for a moment the general distress of the family. It was entirely understandable. It was entirely sincere, and it was grave, I think, on the part of everybody. The court understood that. The lawyers understood that. The jury understood that. We certainly understood that when we participated in the case. Legally, however, I think the case turned out to be quite simple, which is is why it led to an 8-1 decision from the Supreme Court. And the principle that the court announced in an opinion by the Chief Justice, John Roberts, was the First Amendment simply does not permit the government, or in this case a jury, to punish people for expressing views because the jury or the government or anyone else regards those views as outrageous or offensive, that the First Amendment protects our right to say outrageous or offensive things. And I also think it's important for people to understand, because this often gets overlooked in descriptions of the story, that this was a peaceful protest, that the protesters went to the police before the protest began. They said, we intend to protest. Where do you want us to stand? They stood where they were told to stand.
So was Skokie. So there are these cases that the public just cannot understand the ACLU's position on, and in this case the court's position on. I heard so much talk around the water cooler about, oh, they must be crazy. How could this be so? And I don't want to give any money to the ACLU because this is the kind of stuff they promote.
Yeah, well, thankfully I've heard less of the latter than you have, Sandy. But
who's going to say it to you?
But who's going to say it to me? But many people, actually. But these are hard cases. I mean, there is no doubt that they are emotionally wrenching cases. But the entire principle of the First Amendment is that we cannot allow government, and jury is in this case a agent of the government, right? We cannot allow the government to decide what speech is permissible, what speech is not permissible, based upon a majority vote or a unanimous jury verdict about what speech we find acceptable and what speech we don't find acceptable, because the truth in the matter is maybe there is near universal agreement that this speech was reprehensible. That's certainly my personal view. This was reprehensible speech. But there's a lot of other speech out there that is much more controversial, that one part of the community thinks is appropriate and proper and necessary, and another part of the community thinks ought to be censored.
Let me pick up on what Sandy said, because I think it is, you do travel a lot and talk to people, and you're a semi-public figure in the sense that you don't run for office, but often recognizable. Among non-lawyers, we assume that lawyers will have some training to make the leap, at least to understand the principle. Do you find that ordinary folks who talk to you understand that the right to express public policy interests trumps the issue of the pain inflicted on this family, or they're not interested in or capable
and no
of
matter
making
how
that distinction?
ugly the speech is, in
Do
fact,
people understand the
most
principle?
important.
I think if you have an opportunity to explain it to people, people understand this. They think that people ought to have a right to a funeral that has dignity and a funeral that is in some sense private. And so I think many people probably support laws that are being enacted around the country. All 50 states now have these laws, and the federal government, that say funeral protests must be a certain distance away from the cemetery, must be a certain distance away from the church, so that they do not intrude on the dignity of the ceremony. But those laws were not in question in this case. Nothing the Supreme Court decided cast doubt on the validity of those laws. And if you say to people, on the other hand, what was really at stake in this case is the jury was told that you can award a verdict against these speakers if you find that their speech is outrageous or offensive. That was the charge to the jury, right? If you find the speech is outrageous or offensive, you can impose a multi-million-dollar verdict. I think most people are capable of understanding that that's a dangerous power to give to a jury.
Well, before we leave First Amendment, there have been so many First Amendment cases this term. Let's talk about another part of the First Amendment, and that being the church-state question, which some of us thought was going to be answered in the Arizona case, in which there was public money through tax credits that was going to go to parochial schools. The same kind of thing, by the way, that New Jersey is contemplating right now. What happened in that case? Because we didn't get our answer.
We didn't get our answer. The Supreme Court threw the case out without ever reaching the underlying question of whether the Constitution permitted this kind of public, what I would regard as a public subsidy for religion. And they did it by saying that if the government is simply awarding tax credits to individuals who choose to contribute to parochial schools through this state-created entity that existed in Arizona, it's their money and not the state's money, and people can spend their own money however they want, and the Constitution only limits that's the way the Constitution, the state spends its money, not the way individuals spend their money or the credits they get from the government for spending, contributing their money. Justice Kagan wrote her first dissent in the case, and it was an incredibly powerful dissent. And I think what she pointed out is that the distinction the government was drawing between direct government expenditures and tax credits to people who make contributions, because a tax credit means that that dollar you give to the parochial school would otherwise have gone to the state. There were no other choices. It either went to the state or went to the parochial school. That when the government allows you to divert that dollar to the parochial school, it's spending the state's money just as much as if it had written the check out from the state treasury. Every politician understands that. Every economist understands that. And the court, I think, just blinked at reality when it held otherwise.
In applauding Justice Kagan's dissent, the New York Times says that the court's ruling was another cynical sleight of hand.
Well, the Times can call the court cynical. I'm not going to call this court cynical. But
Too many cases.
You have to handle
cases.
Right, I'm a better lawyer than that. But I think it was mistaken. I think they took a very simplistic approach, and the argument was actually very interesting because it sounded like the kinds of political discussions you have going on now about whose money is it? Is it the taxpayers' money? Is it the government's money? There was that fight was going on back and forth in the court, and one of the justices, and I can't remember who, said, "I don't understand. The money's sitting in my wallet. At what point does it become the government's money?" But one of the things that Justice Kagan sent in her dissent was, to the extent that people were upset, for example, about the recent bailout of failing corporations and failing banks, they wouldn't have felt any less troubled if instead of writing out a check, the government just said to the corporations, "We're going to allow you to take money off your next year's tax return." Everybody would have understood that was just two ways of accomplishing the same thing. The same was true here.
In addition to being a First Amendment case, this case is also in a category of, I like to call them access cases, you call them court closing cases, where the court reaches a conclusion that the journalists would say, from a technicality point of view, we would say lawyers procedurally, where they don't reach the merit, the real question. Is that happen, forget the Times hypothesis about cynicism, does that happen because some justices decide maybe they can't win on the merits, or is there sometimes a genuine commitment to saying we're not going to get to the constitutional question unless we have to?
No, I think there's a genuine ideological divide in the court between people who, on the court, who think that over the years the court has reached out to decide too many issues that ought not to be decided by judges, ought to be decided by elected representatives, and people who think that the role of the courts is to do justice. And if somebody comes to a court and says, my rights have been violated, they are entitled to a hearing on that claim. I'm in the latter category, I'm not in the former category, but there is no doubt that over the past several decades, and it's embraced by the current Supreme Court as well, there is a majority of the court that increasingly is looking for ways to shut the courthouse doors and deny people the right to stand up in front of a judge and say, let me make my case.
Let me take you in a completely different direction. Extraordinary rendition. Something that just doesn't seem to go away no matter who's in the White House. Although the case in question goes back to when John Ashcroft was the Attorney General. Ashcroft versus Abdul Al-Kid. Tell us about that.
So Abdul Al-Kid is not actually an extraordinary rendition case, just to be fair. Extraordinary rendition involves kidnapping somebody in one place and bringing them to another place to be questioned. And we have one of those.
Well, we do have another of those, that's right.
But Al-Kid is certainly a post 9/11 case, and he is an innocent victim of the sort of post 9/11 crackdown. And what happened to Al-Kid, in a nutshell, he had graduated from the University of Idaho. He was a star football player at the University of Idaho. The FBI was conducting a terrorism investigation in Idaho. He, as far as he knew, was not a target of the investigation. They never suggested to him that he was a target of the investigation. They were investigating somebody else who they ultimately indicted. That person was acquitted, by the way, at trial, but he was indicted. And they came to Al-Kid and they said, we think you know him. Are you willing to talk to us about him? And Al-Kid said, I'm happy to cooperate. And every time the FBI came to him, he cooperated fully. He answered all of his questions. As far as he knew, they were done questioning him.
And most important, perhaps, Steve, they don't send him a letter saying, don't go anywhere, we want to keep questioning you.
They never tell him that. Right, exactly.
He's on his way to Saudi Arabia to school.
He's on his way to Saudi Arabia at school. He makes it from Idaho to Dulles Airport. He's getting ready to board the plane in Washington, D.C. to go to Saudi Arabia. California, and he is arrested by FBI agents. He's taken out of the airport in handcuffs. He is then transported across the country in a 15-day journey from hell, where he is held in solitary confinement in jails across country.
So not extraordinary in that he's not taken out of the country, but extraordinary in that he is held in a way that is certainly disturbing, and nobody knows where he
extraordinary
is.
in the sense that the authority for arresting him was not because he was suspected of a crime, but because they told the judge in Idaho that he was a witness that they needed to testify in somebody else's trial.
So the question becomes, did they use that as a pretextual excuse, right? Is that what they did? And that's what you
and that's what we claim,
that's what you said.
That's what we say. And here's two sort of critical pieces of evidence in support of that, right? If somebody's a witness, you don't handcuff them and hold them in solitary confinement for 15 days as you take them across the country. First of all, that's no way to treat a witness. Secondly, you generally want your witnesses to be friendly and cooperative, and you don't accomplish that by locking them up in solitary confinement. Two, we know after the fact that he was never called. This
and
trial
they
took
restrict
place.
his movement for 15 months?
And so they hold him in jail for 15 days. They bring him back across country and to Idaho. The judge says, you don't have to hold him in jail anymore, but I want you to surrender your passport, and you cannot leave a four-state area. And those restrictions remain in place until after the trial, where he is never called and where the defendant is acquitted by a jury.
What does Ashcroft say in response to all this?
Ashcroft says in response to all of this, you have no right to sue me because I am the Attorney General, and the Attorney General is the chief prosecutor for the United States, and prosecutors can't be sued even if they violate people's rights.
So he does not deny that he might have sent the word to use the material witness statute to hold on to people who might have been thought as perhaps being dangerous as terrorists.
He does not deny it, but I want to be fair to him, which is that the sort of way many of these lawsuits proceed is that if you think you have a legal grounds for dismissing the lawsuit, and he thought he had a legal ground, I'm the Attorney General, I can't be sued, you come into court and you say, even if everything you say is true, this case should still be thrown out. Now, if we prevail in the Supreme Court, I have no doubt he's going to come back and say what you were claiming is not true. But the case as it exists in the Supreme Court is proceeding on the assumption that our version of the story is accurate. And assuming it's accurate, the question is, should you be able to sue the Attorney General? And we have won this case. We won this case in front of the trial court. We won this case in front of the Federal Court of Appeals. It's going to be a tough road in the Supreme Court. We don't have a decision yet. We will see what the Supreme Court says.
Another case that isn't yet at the court but is seeking certiorari, which is an extraordinary rendition case. First, you got to explain, you don't automatically get to the Supreme Court. You have to ask permission to get there.
You have to ask permission to get there. In the federal court system, there are 3 levels. You start at the trial court, you get 1 automatic appeal to level number 2. But if you want to go to level number 3, you have to ask the Supreme Court's permission, and the Supreme Court gets thousands of requests every year, and they grant.
This year you had how many cases?
80
cases.
They grant 80. So statistically, your odds are not great.
Now, this case, Jeppesen Dataplan, is closely watched in some circles because it's about extraordinary rendition, and it's a case in which the plaintiffs, several of them, sued the air carrier, the private carrier, who had, according to them, shipped people around the world to be tortured at the behest of the United States. The United States wasn't a party. It intervenes.
Yeah.
And what happened?
Jeppesen is a division of Boeing, a wholly owned subsidiary of Boeing. They didn't actually operate the planes. They did the logistics. They were, as they described themselves, and reportedly the travel agents to the CIA. They made all the arrangements. And so we sue Jeppesen, and the government comes in, and the government says, we're not going to allow you to sue them, and then we're not going to allow them to defend themselves. Because if this case goes forward at all, it's going to require the disclosure of what we claim are state secrets. And because there are state secrets involved in this case, the entire case should just be thrown out at the outset.
And your response to this idea of state secrets trumping everything?
Well, the number one, if the government has some state secrets, maybe they can withhold a specific piece of evidence, but let us try to prove our case based upon what's in the public record. But more to the point, there has been a tremendous amount of attention paid about this program of extraordinary rendition. It has, the administration has acknowledged it. What has happened to these particular individuals.
And it is continuing, is it not?
It is continuing in a different fashion. The Obama administration says they will not render people to torture. They will move people from place A to place B, but not for the purposes of torturing them.
And the new guidelines are cited in the opinions on appeal. But.
And the other thing to be said that hasn't changed in the new administration is the initial claim of state secrets in this Jepson case was made by the Bush administration. The case was argued on appeal a week after the Obama administration's inauguration. And so the first question the government lawyers got from the bench is, do you have anything to tell us? Has the government changed its position under the new administration? And the answer was no. But the point I was going to make about the extraordinary rendition is there have been, I cannot tell you how many newspaper articles, how many official investigations around the world, how many public statements there have been by people in positions of authority, beginning with President Bush on downward, acknowledging the fact that we engaged in extraordinary rendition. And nonetheless, the government comes into court and says this is a secret. And so my response to that is we now have a situation where the government is engaging in a practice that when it happened in South America, we used to talk about the disappearance of people, that is being discussed around the world, and the one place we are told we cannot talk about it is in a U.S. court of law. And whatever the legal doctrines are, that cannot possibly be the right answer.
And it's got a lot of judicial attention. You lost in the first court, the circuit reversed, and then there was something called an en banc where a bigger bunch of judges from the circuit sat.
We lost in round one. We won in round two. We lost in round three, and now we're on our way to the Supreme Court, and we will see what happens. We will know by the end of this spring whether the court has agreed to hear the case.
Worldwide interest in this case.
Yes, I think that's right. And if they hear it, it'll be next year. We can talk about it next year.
One of the cases that was decided, and anybody who saw last Sunday's op-ed page in the New York Times had to be struck by this amazing first-person account by John Thompson. Spent 14 years on death row, more years than that imprisoned, finally is exonerated, is freed, sues, gets a $14 million jury verdict. It goes to the court, and here we come back to this idea of whether you can sue a prosecutor.
Right. 5-4, they throw out.
In this case, the New Orleans prosecutor, Connick.
Right. Father of Harry Connick Jr.
Yes, indeed.
They threw out the case 5-4. And there are some constitutional cases that reach the Supreme Court and have a certain air of abstraction to them. There are others that I think are really easy to understand at a personal and visceral level. The funeral protest case was one. This case was another. This is a man who was wrongfully convicted. As you say, he spent 18 years in prison. He spent 14 years on death row. Several times he was within hours of his execution. And only by happenstance.
And all because
the prosecutors in New Orleans withheld critical evidence that his defense lawyers were entitled to receive, which indicated that blood samples they had found at the scene of the crime did not match his blood type.
So then why does the court say the jury was wrong?
And the court says the jury was, not that the jury was wrong on the facts, but
say the jury can't give him
the jury doesn't get to decide this question. Mm-hmm. And the reason the jury doesn't get to decide this question is because it's not fair to hold the Orleans Parish District Attorney's Office responsible for the single mistake of one of its prosecutors, however horrendous that mistake may have been and whatever the consequences may have been for the individual who was wronged. And there are multiple things, I think, wrong with that decision, all of which are pointed out in the dissent. First of all, I don't think it was a single error. And secondly, I think that the responsibility, the constitutional duty of prosecutors to turn over evidence to the defense that may in fact prove that the defendant is innocent is so clearly grounded. And the office's responsibility to train its prosecutors about their constitutional duties, and the predictability that if they don't, it's going to lead to tragedies like this.
And predictably, we've got 45 seconds left. So I want to ask you, what in this term? First of all, how was this term? We didn't have a Citizens United. We didn't have one blockbuster case. Yeah. But in the next 30 seconds, What was it about this term that struck you the most? We started with you saying the 3 women.
Yeah, well, let me say, it's you know, for me, a Supreme Court term is like a Broadway season. Sometimes there are blockbuster shows, more blockbuster shows than others, but the season is always interesting, and that's true this year as well. But I do think that the most dramatic thing about this year's term is to sit in that courtroom and look up and see 3 women on the bench for the first time in American history. And I think it has not only an enormous symbolic importance, I think it has substantive consequences for the way the court approaches and decides cases as well.
In one word, can you tell me
Shapiro,
what the substantive consequences?
I don't think so.
Oh, you can't do it. Okay.
Steve Shapiro, it is always an education to have you here. We will make it a date again, I hope, for next year.
I'll be here.
In the meantime, Steve, you and those of you at home can watch us every week for more of what matters in law and justice.
And you can visit us on Facebook at facebook.com/Due Process TV, or talk back to us at dueprocesstv@gmail.com. Till next week, with our thanks to Steve Shapiro, for Sandy and all of us here at Due Process, thanks for watching.
To the liberal-conservative divide, one of the things that I find troubling about the current composition of the court is on cases where the court divides 5-4, not always, but frequently now, you have not only liberal versus conservative, but you have on one side 5 men, and on the other side 3 women and Justice Breyer. And you have on one side 5 Catholics, and you have on the other side 3 Jews and Justice Sotomayor. And whatever else you say about the court and the country, that is not a good way to divide our Supreme Court.
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.